This is a judgment of the court. Can you hear me?
Yes, my lord. I can hear you.
The claimant commenced this suit by way of complaint filed on 28th day of April 2023, pursuant to the 302 of the National Industrial Court of Nigeria Civil Procedural Rules. Whereas the claimant claims against the defendant the following reliefs: a declaration that the suspension and the dismissal of the claimant by the defendant were wrongful because the claimant is not guilty of the allegation of double timing, being one of the grounds for his dismissal, and that the defendant is stopped from dismissing the claimant on the ground that he was not qualified at the time of his employment because the defendant employed him on certificates he presented. A declaration that the reasons for the suspension and dismissal of the claimant by the defendant are baseless, manufactured in bad faith, and unjustified. An order of this honorable court setting aside the suspension and dismissal of the claimant by the defendant for being unlawful and wrongful. An order of this honorable court reinstating the claimant as the director of works and maintenance in the defendant. An order of this court compelling the defendant to pay the claimant his complete salary during the period of wrongful suspension, and thereafter to pay the claimant his full salary and allowances until his reinstatement, and thereafter until he retires or resigns or otherwise. General damages in the sum of 500 million naira for humiliation, emotional trauma, and pains of victimization. The claimant predicated his claims on the statement of fact and witness statement on oath filed on the 28th day of April 2023. The defendant based its defense on the statement of defense and a witness deposition oath filed on the 5th day of July 2023, wherein the defendant counterclaimant counterclaims against the claimant counter-defendant as follows: the sum of 6,761,776 naira being the total salary fraudulently received by the claimant from the defendant counterclaimant, and 10% interest on the judgment sum till the claimant liquidates the judgment sum. At the plenary hearing on the 4th day of October 2023, the claimant called his first witness. The claimant, who testified for himself herein after referred to as CW1, identified his deposition made on oath on the 28th day of April 2023 and adopted same as his evidence in support of his case. CW1 thereafter tendered exhibit CW001 to CW019. On the 19th day of October 2023, the defendant opened its Lukman Ababieka, hearing referred to as DW1, testified for the defendant. DW1 identified his statement on oath filed on the 5th day of July 2023 and adopted same as his evidence in support of the defense of the defendant. And again, Ademola Salami, hearing referred to as DW2, testified on behalf of the defendant. DW2 identified his statement on oath filed on the 5th day of July 2023 and adopted same as his evidence in support of the defense of the defendant. After the close of hearing of this suit, on the 6th day of May 2025, the matter came up for adoption of final written addresses filed by counsel. Learned counsel for the defendant, Sabio L. Tani, identified his final written address filed on the 1st day of December 2023 and adopted same as his legal submission in the aid of the case of the defendant and urged this court to dismiss the suit. Counsel for the claimant, Christopher Okaf, identified his final written address filed on the 4th day of December 2023 and adopted same as his legal submission in the aid of the case of the claimant while urging this court to grant the claim of the claimant. Let me briefly state the case of the claimant in brief. The fact of this case, as pleaded by the claimant in his statement of fact, are that the claimant was until February 14, 2023, the Director of Works and Maintenance in the defendant before he was dismissed. The defendant had advertised in the Nation and the Vanguard newspapers of May 28, 2021 for several positions, inclusive that of the Director of Works and Maintenance. In the newspaper advert, the defendant stated as a qualification for the position of Director of Works and Maintenance to be that the candidate must be a fully registered engineer with a good honor degree or a registered engineer with a master's degree in relevant field with at least 15 years post-qualification cognate experience. At the relevant time, the claimant had an HND and postgraduate diploma in marine engineering from Naval Engineering College, Sapele, Delta State, and Rivers State University, respectively. Further stated that claimant was employed in the Bayelsa State Ministry of Transport and had applied to the Council for Regulation of Engineering in Nigeria, CORED, for registration. Sequel to the said advert, the claimant applied for the position of Director of Works and Maintenance in the defendant and was invited for an interview. At the interview, the claimant presented all his qualifying documents and disclosed to the interview panel that he was qualified to be registered as an engineer by CORED and had submitted his application for registration. Interview panel advised him to get registered within 1 year if the defendant employed him. The defendant, by a letter of appointment dated 16 July 2021, offered to the claimant the job of Director of Works and Maintenance in the defendant. The claimant accepted the letter of appointment to resume work at the defendant and within 6 months got registered as an engineer by CORED. In May 2022, a new rector, Dr. Lukman Adegoke Ababek, assumed office as the new rector of the defendant. At the assumption of office of the new rector, it was noticed that the school environment was overgrown with weeds, and the rector rightly instructed the claimant to clear the sediments. The claimant explained to the rector that the acting rector, before his assumed office, was cleaning the compound through the DSA at the cost of 800,000 naira per month, and that the school did not employ gardeners because the cleaning of the compound was outsourced to the youth of ECOB, a local content policy. The claimant presented a reduced amount of 450,000 naira for the cleaning of the compound as a budget, but the rector noted that the school does not have such money, but rather suggested to the claimant to instruct the staff under the Department of Works and Maintenance to clear the compound. On the instruction of the rector, claimant instructed the staff of Works and Maintenance Department of the defendant to cut the grasses in the school, but the staff refused, arguing that they were not employed as gardeners. The claimant reported this development to the rector, whereupon the rector instructed the claimant to issue a query to the staff who refused to carry out the instruction to cut the grasses and submit names of those who refused to comply to the rector. The claimant issued the query in accordance with the rector's instruction and duly informed the rector, who turned around to blame the claimant for not copying him. On the 13th day of July 2022, the rector served him a letter captioned "Dereliction of Duty," wherein the rector alleged that the claimant was shielding the queried staff who refused to cut grass, and then directed the claimant to ensure that the staff cleaned the entire school compound before 17th day of July 2022. In compliance with the rector's letter of the 13th day of July 2022, the claimant called the staff and instructed them to clean the school compound as directed by the rector, but the workers stuck to their guns that they were not employed as gardeners, and the claimant submitted the names of the queried staff with their queries to the rector. Due to the intransigencies of the workers in not cutting grass and cleaning the compound, the rector made out a total of 450,000 naira for the grass cutting and termed it as a loan, which the workers must pay back by way of salary deduction. With the money the rector made available, the claimant engaged the host community, who cleared the school compound, whereupon the claimant retired the money by stating how it was spent in accordance with the practice. The claimant was surprised to receive a letter dated 22nd day of July 2020 from the registrar, placing the claimant on suspension with 50% salary and some hitherto unknown grounds of refusal to carry out a lawful instruction from the superior, insubordination, that is, refusal to respond to a query of insubordination, misappropriation and investment of funds, and sabotage, locking the fuel station for 2 days. The claimant was stunned by the new allegations because he carried out all the rector's instructions, acquiring the erring staff and submitting their names to the rector. The letter of 13th day of July 2022 merely instructed him to carry out the rector's instruction and not to respond to it. The claimant accounted for the money given to him by the rector and retired same formally. The allegation of embezzlement was ambiguous and lacked specificity. The claimant was not in charge of the central store where diesel are stored, and the issue of diesel storage was not under work designation of the claimant. The claimant defended those allegations in his letter to the Governing Council, dated the 28th day of July 2022. While he was trying to contest the irregularity of his suspension, especially as it has to do with the allegation of not responding to a query, the claimant received through his WhatsApp on the 4th day of August 2022 another letter dated 13th July 2022, which appeared to be the same the earliest one he received, only to find out that the last line has been corrected to read, hence you have to explain in writing with evidences within 48 hours of receipt of this query, while disciplinary action should be taken against you by the management. The letter of 13th day of July 2022, which he received via WhatsApp media, is different from the one he received earlier, whose last line reads, you are to ensure total compliance with the receipt of the letter. The letter dated 13th July 2022, received by the claimant via WhatsApp, was intended to regularize the suspension of the claimant on the ground of insubordination, when the earlier letter of 13th July 2022, received by the claimant physically on the 13th day of July 2022, instructed the claimant to comply with the rector's instruction. The letter dated 13th July 2022, sent to his WhatsApp, was sent while he was on suspension, and he responded to the delivery of the letter through WhatsApp and the clear attempt to set him off for insubordination with the letter of 8th day of August 2022. While on suspension, the claimant received another query dated 9th day of August, alleging the inappropriate utilization of the sum of 445,000 naira over invoicing for water treatment and general services, habitual absenteeism from work, locking up diesel purchase for use in the school, and double time. The allegation in the query of the 9th day of August 2022 are what have been alleged against him, with additional charges of double timing and over invoicing. Yet the claimant responded through a letter of 11th August 2022, defending all the allegations against him. The claimant received another letter dated the 19th day of December 2022, dismissing him from employment for not possessing the requisite credentials for holding 2 full-time jobs. The defendant, the rector, singled out for victimization or for no reason at all, and suspended and dismissed just to victimize the claimant. The claimant had altered his position by quitting his job at Bayelsa State Ministry of Transport and is working fully for the defendant based on the offer of employment from the defendant. The defendant stated that the claimant's biological brother was the immediate first. The case of the defendant is that the defendant stated that the claimant's biological brother was the immediate substantive rector of the defendant, who used his position to employ the claimant without following due process, particularly as regard to qualification of to the position of Director of Works in Xavier, you are disturbing me here, please.
Mute yourself now.
Mute yourself. Without due process, particularly as regard the qualification of an applicant to the position of Director of Works in the defendant institution, as contained in the advertisement of 28 May 2021. At the time of the alleged employment of the claimant was in the salary employment of Bayelsa State Government, which fact was concealed by the claimant during the process that led to the claimant's alleged employment. After the claimant alleged employment with the defendant, the claimant was still receiving salary from Ministry of Transport Bayelsa State, while simultaneously receiving salary from the defendant for more than 4 months. The claimant was not lawfully employed on the ground that the claimant was above 50 years of age at the time of the claimant's alleged employment by the defendant, contrary to the Extant Public Service Rules 2006. The claimant was not only a member of staff of Bayelsa State Civil Service, he was also not qualified for the job of Director of Works, as he did not possess the requisite qualification listed in the publication for the office of Director of Works in the defendant before he was allegedly employed. is also a pensionable appointment, employment. No approval from the appropriate authority was first had and obtained before the claimant, who was above 50 years at the time of his alleged employment by the defendant, was employed. The defendant further stated that the defendant stated therein the qualifications that all applicants must possess before applying for any position advertised. But the employment of the claimant fell short of the said requirement, as the claimant's employment was manipulated by the former defendant's rector, who was the claimant's biological brother. The employment of the claimant into the institution was influenced by the claimant's elder brother, Professor Enetimi Idaseb, who was then director of the defendant between 2016 and July 2011, and in collusion with the chairman of the governing council of the institution, who is also an in-law to the claimant. The claimant knew that he was a member of staff of Bayelsa State Civil Service at the time of his employment with the defendant, and still accepted the second employment, which both are pensionable. In the Department of Works, there is a unit of parks and gardens whose duties, among others, are to clear the grass or weeds in the premises of the defendant, with employees earning salaries for that purpose. The claimant had the instruction to utilize the staff of the defendants who were employed to clear and cut grass, but the claimant has been collecting several amounts of money, running into millions of naira from the defendant to clear the premises of the defendant, even though there are staff employed for this purpose. The reduction of the money by the claimant employed staff to clear the premises, to clear and clean the premises of the defendant. The claimant was instigating the staff employed in the park and garden unit of his department against the rector, which made the said staff initially refuse to carry out the rector's instruction that the staff should perform the jobs for which they were employed and being paid for. The claimant never allowed the rector's instruction. Rather, he was covering up the said staff and reported to the rector that the staff planned to hire people from outside the defendant to come and clear the compound, and the staff would pay the cost themselves, which plan the rector rejected, as the rector insisted that the staff who cannot perform the job for which they were employed should either resign or do clearing personally. When the staff persistently refused to clear the compound, but insisted that they will hire people to clear the premises to avoid face-off with the host community in the early life of the rector's tenure, the rector then graciously decided to assist them by raising the said 450,000 naira for them as loan, which they shall pay back. The claimant surprisingly never utilized the money for the purpose for which the money was released to him, as he did not even pay or settle the host community youth that did the job. The claimant was suspended pending when his matter was decided by the governing council of the institution, which later ratified the said suspension, as according to the governing council, the claimant was deemed never to be in the employment of the defendant, having not qualified in the first instance, but misrepresented facts about the employment by the Bayelsa State during the claimant's employment process. The claimant was double timing, as he's a pensionable officer in the Bayelsa State Civil Service and also in full-time The issues for determination of this suit are as follows: whether the defendant has proved the reasons for dismissal of the claimant from the employment of the defendant, thereby justifying the dismissal of the claimant. And secondly, whether the defendant has proved the counterclaim raised against the claimant counter-defendant to enable the counter-claimant to the relief sought. So I will skip your legal arguments and I will go to the decision part of this judgment. Can you hear me? Can you hear me?
Yes, my lord, we can hear you now. Or I can hear you now, rather.
So let me go to the decision part of this judgment.
As court pleases.
I have carefully analyzed all the processes filed, including the evidence adduced and all the exhibits tendered. On issue 1, as a prelude to the resolution of this issue, it is essential to recap that the burden of proof rests squarely on the claimant, who must prove his case on balance of probability. And where a claimant fails to discharge the burden to prove their case as required by law, it is needless for the court to call upon the adverse party, who is a defendant, to disprove what has not been proved. In civil cases, the plaintiff must prove their case on balance of probabilities, sometimes which is styled as preponderance of evidence. A claimant can only succeed in obtaining judgment in his favor from the court on the strength of his case and not on the weakness of the defense, unless he finds in the evidence of the defense facts which strengthen his case. See the case of Wife 1, Wife Body against Agio, UBA PLC against Samba Petroleum Company Limited, Ojo against Azam. In the case of OKBMM against UBM PLC, the Court of Appeal held that, and I quote, Section 131 and Section 131 of the Evidence Act are on point. A claimant is required to call evidence and prove all material abatements contained in his statement of claim, over which himself and the respondent have joined issues, unless it is admitted by the party on the other side. In that case, the plaintiff may be absolved from the duty on him to further lead evidence to prove it. Unquote. Without gainsaying, there are 3 categories of employment. We have the pure master-servant relationship, and we have servants who hold their offices at the pleasure of their masters or employer. And then we have employment with statutory level. In the master and servant relationship, the master has an unfettered right to terminate the employment. However, in doing that, he must comply with the procedure stipulated in the contract. In a contract with statutory level, the employment is protected by the statute. In the event of termination of employment with statutory level, strict adherence must be had to the statute creating the employment. See the case of Longi against Space Bank Nigeria PLC, Mobile Producing Nigeria Limited against Johnson, and Oforisha against Nigerian Gas Company Limited. The Supreme Court, in Kwara State Judicial Service Commission against Tolani, held as follows, and I quote, I agree with the learned counsel for the respondent that from the above highlighted undisputed facts, it is clear that the respondent's employment is close with statutory level. The 3 factors that must coexist to constitute a public office, namely that the office was created by the Constitution, statute, order, enabling legislation. Secondly, that its function, duties, and powers are as defined by law and other regulations. And thirdly, that the position must show some permanency. And a public officer is one in the public office of the government of the Federation or state, as defined under the heading Public Service of the Federation or of a state as per Section 2771A, B, C, D, E, F of the Constitution, unquote. In this instant suit, the defendant is a creation of statute under Section 14 of the Federal Polytechnic Amendment Act 2019. And Section 17 of the Federal Polytechnic Act, the principal act, deals with the removal and discipline of academic, administrative, and technical staff, thereby bringing the employment of the claimant with the defendant under purview of the employment which enjoys a statutory level. The claimant pleaded and led evidence to state that the defendant advertised in the Nation and Vanguard newspapers of May 28, 2021 for several positions, inclusive of Director of Works and Maintenance. In the said newspaper advert, the defendant stated as a qualification for the position of Director of Works and Maintenance to be that the candidate must be a fully registered engineer with a good honor degree or a registered engineer with master's degree in relevant field with at least 15 years post-qualification cognate experience. At the relevant time, the claimant had an HND and postgraduate diploma in marine engineering from the Naval Engineering College, Sapele, Delta State, and Rivers State University, respectively. The claimant further stated that he was employed in Bayelsa State Ministry of Transport and had applied to the Council for Regulation of Engineering in Nigeria, current for registration. And sequel to that advert, the claimant applied for the position of Director of Works and Maintenance in the defendant. He was invited for an interview.
Sorry, I'm not hearing the cut.
I think he logged out. Maybe his network.
You're right. I'm not going to see him on the panel.
The defendant, by a letter of appointment dated 16th day of July 2021, offered to the claimant the job of Director of Works and Maintenance in the department in the defendant, Beard Exhibit CW001. The claimant accepted the letter of appointment, resumed work at the defendant, and within 6 months got registered as an engineer. Registered as an engineer by Koren. The claimant tendered his membership certificate of Koren as XBCW015. The claimant received a letter dated 19th day of December 2022 dismissing him from employment for not possessing the required credentials and for holding 2 full-time jobs. The dismissal letter of the claimant is admitted in evidence as Exhibit CW007. Gleaning from the gamut of evidence before me, the claimant has established that the defendant employed the claimant via the Exhibit CW001, and his employment was subsequently dismissed through Exhibit CW007. The Court of Appeal, in the case of Momo against CBN, held that, and I quote, "It is a time-hallowed principle of law that a plaintiff, as in the instant case in a contractual employment, who alleges that his employment was wrongfully terminated, has a strict burden placed upon him to establish the following material facts. A, that he's an employee of the defendant. B, the terms and conditions of his employment. And C, the way and manner by which he can be removed." Unquote. A crucible perusal of the pleadings and the relief sought by the claimant in his statement of facts, I am without a shred of doubt that the claimant does not challenge his dismissal based on non-compliance with the terms and conditions of his employment. The basis for challenging his dismissal is premised on the reasons given by the defendant for dismissing him from employment. Though counsel for the claimant, in paragraph 1 to 6 of his final written address, sternly and surprisingly argued that the suspension and dismissal of the claimant from the employment of the defendant is wrongful because the defendant did not set up a panel to investigate any allegation against the claimant. The defendant did not invite the claimant to defend himself. The panel of the defendant did not submit any report to the counsel. The defendant just sent a letter of suspension dated 22nd day of July 2022 as required under paragraph 6.9.64 of MBT. I am shocked by the strange argument of the claimant. As the claimant throughout his pleading before me did not challenge his dismissal from employment of the defendant based on non-compliance with any law, nor did the claimant plead the MBT conditions of service. Let me say this. The traditional practice and procedure of the adversarial proceeding is that cases are won and lost on basis of pleadings and evidence before the court. The court frowns at the habit of counsel debating from 4 walls of pleadings and evidence before the court. Judicial proceedings are unlike ultimate sea coaster, where passengers control at will the movement and speed of coaster in the sea. It is the pleadings and evidence that determine the fate of parties to the suit, not even the judge. Because parties and the court are bound by pleadings and evidence, judgments which found to have deviated from pleadings and evidence of parties are not only favors, but also lead to miscarriage of justice. The Supreme Court in the case of Ongba against Onyema, reported in 2022, 17 NWLR Part 1858 at page 97, noted that a final address is the ultimate speech for submission made in court in respect of the matter before the delivery of judgment. A final address consists of a summary of parties' case. It is a submission of facts admitted, proved, or deemed conceded in the trial, and the application of the law to those facts. It also highlights any important issue of substantive law or procedure that might result in a decision in favor of parties' position. Final written addresses are only designed to assist the court, although where the facts are straightforward and primarily not in dispute, the court may even dispense with final written address. Notwithstanding the importance of legal submission of parties, it is not an avenue to change the character of the case before the court. Counsel are not expected to be chameleon-like, but must maintain a stand and be consistent with it throughout the proceedings. The address of a counsel, no matter how well prepared and persuasive, cannot take the place of credible evidence. See the case of Vince International Nigeria Limited against Maro Hundia. In view of that, I hereby ignore the submission of the learned counsel for the claimant, which found to be outside the frame of pleadings and evidence before me. The suit of the claimant is challenging his dismissal from service of the defendant for reasons stated in Exhibit CW007. For ease of reference, let me produce the content of the Exhibit CW007, which is a determination letter. And it reads, and I quote, "Dear Mr. Sayebo Oyinku, termination of appointment. The Governing Council, that is Council Disciplinary Committee of Federal Polytechnic Yenegoa, at its 28th regular meeting held between 12 to 14 December 2022, received and considered the report and recommendation of Staff Disciplinary Committee on gross misconduct for holding 2-time paid jobs, double time, made against you, contrary to public service rules and MBT revised conditions of service applicable in the Federal Polytechnic. Also, your appointment appraisal show that you are engaged in error because you do not possess requisite credentials for the Office of Director Works and Services as stipulated. Having considered the totality of evidence and submissions, the Governing Council decided to uphold the recommendation of the Staff Disciplinary Committee to dismiss you from the services of the Polytechnic as Director of Works and Services. In view of the above, you are hereby dismissed from the services of the Federal Polytechnic Yenegoa with effect from 14th December 2022. You are to hand over all property and documents of the Polytechnic in your custody, including staff ID card, car plate number, and to the office of the registrar with immediate effect. A copy of this letter, all relevant authorities of the Federal Polytechnic Yenegoa are required to ensure compliance. Unquote. The principle of law at common law: for a master to dismiss a servant from his employment with reasons or no reason, and in consonance with this principle, the courts rarely order specific performance of contract of employment so as not to create a situation whereby an employee will be foisted upon an unwilling employer, just as no employer could be allowed to prevent an employee from seeking redeployment elsewhere. However, where there is a written contract of employment, statutory provisions and regulatory conditions of service, equity demands that the court should hold the parties bound by the terms of employment or agreement. See the case of Momo against CBN. And Momo against CBN. The Court of Appeal in NEPA against Ade, while affirming the decision of the trial court, held that the learned trial judge, in considering the reason for dismissal of the plaintiff contained in Exhibit 3, said in her judgment at page 56 of the record as follows, and I quote, "The disturbing aspect of the case border on the reasons given for the dismissal, which the employer was not obligated to give. But once reasons are given and they are disputed in court, as in this case, the onus now lies on the employer to justify the reasons by evidential proof. The proof required here is proof beyond reasonable doubt, as required in Section 137 of the Evidence Act. The proof is necessitated by the allegation of criminal misconduct leveled against the plaintiff, for which he was suspended and later dismissed. This reasoning by a trial judge cannot be faulted." Unquote. Again, the Supreme Court in the case of IHABUHMB against INP, where the court held that, and I quote, "Although it is right that the employer is not obligated to give any reason for firing his servant, all the same, it is set law that where he has preferred any reason at all, it is obligated to satisfactorily prove the same, as the onus is on him in that regard. Otherwise, the termination of dismissal may constitute a wrongful dismissal without merit. The lower court has found that the appellant has failed to justify the dismissal. Hence, it has been found to be wrongful." Unquote. In view of the exposition of the established principle of law, the defendant has the burden to prove the allegations for reasons stated in Exhibit CW007, on the basis of which the defendant dismissed the claimant from the employment of the defendant. On the first arm of the reason for dismissal of the claimant, the defendant stated that the claimant's biological brother was the immediate first substantive rector of the defendant, who used his position to employ the claimant without following due process, particularly as regards the qualification of an applicant to the position of Director of Works in the defendant institution, as contained in the advertisement of 28 May 2021. The qualifications that all applicants must possess before applying for any position therein advertised for, but the employment of the claimant fell short of the said requirement, as the claimant's employment was manipulated by the former defendant's rector, who was the claimant's biological brother. The employment of the claimant into the institution was influenced by the claimant's elder brother, Professor Enetimi Ida Soyabu, who was then director of the defendant between 2016 and July 2011, in collusion with the chairman of the governing council of the institution, who is also an in-law to the claimant. The claimant pleaded otherwise and laid evidence to state that the defendant advertised in the Nation and Vanguard newspaper for several positions, inclusive that of the Director of Works and Maintenance. And in the advert, the defendant stated the qualification for position of Rector and Director of Works and Maintenance. Further stated that the claimant was employed in the Bayelsa State Ministry of Transport and had applied to the Council for Registration of Engineering in Nigeria warrant for registration. And sequel to the advert, the claimant applied for the position and he was invited for interview. And at the interview, he tendered exhibits CW008, 9, 10, 11, 12, and 13. And he disclosed to the panel of interview that he was qualified to be registered as an engineer by Koren and had submitted his application for registration through exhibit CW016. But the interview panel advised him to get registered within 1 year if the defendant employed him. The defendant, by a letter of appointment dated 16 July 2021, offered to the claimant the job of Director of Works and Maintenance in the defendant beared exhibit CW001. The claimant accepted the letter of appointment, resumed work, and within 6 months got registered as an engineer by Koren. The claimant tendered his membership certificate of Koren as exhibit CW015. The claimant received a letter dated 19 December 2022 dismissing him from employment for not possessing the requisite credentials and for holding 2 full-time jobs. The dismissal of the claimant letter is admitted as exhibit CW007. From the advertorial, which is exhibit CW018, the defendant called for applicants for appointment into various offices of the defendant, among which is the position of Director of Works and Maintenance of the defendant. My understanding of this requirement is that the applicant must either be a fully registered engineer with a good honors degree with at least 15 years post-qualification cognate experience, or the applicant must be a registered engineer with a master's degree in the relevant field with at least 15 years post-qualification cognate experience. In either case, the applicant must be a registered engineer. However, the claimant at the time of his appointment held a higher doctorate diploma in marine/mechanical engineering, that is exhibit CW10, and a postgraduate diploma in marine engineering, exhibit CW011. The claimant in his pleadings and evidence told this court that during the interview with the defendant, the claimant informed the panel that he applied to be a member of Council for Regulation of Engineering in Nigeria, and the panel told him to get registered within a year if he eventually got employed by the defendant. He got registered with the Council for Regulation of Engineering in Nigeria after 6 months of his employment with the defendant. Exhibit CW15 is evidence that the claimant registered with the Council for Regulation of Engineering in Nigeria on the 16th day of December 2021. It is glaring, without the aid of microscopic device, that the claimant was not a fully registered engineer or a registered engineer as required in the advertorial as contained in exhibit CW018. The defendant, being aware that the claimant is not a registered engineer, offered the claimant the appointment as shown in exhibit CW001. I think the employment of the claimant by the defendant is fraught with irregularity. But the question is the irregularity of the appointment of the claimant void? I will revert to this question later. But for now, let me consider another issue that relates to the appointment of the claimant. The defendant pleaded and led evidence to state that the claimant was not lawfully employed on the ground that the claimant was above 50 years of age at the time the claimant's alleged employment by the defendant, contrary to the extant public service rules. This piece of evidence is uncontroverted, even though the defendant did not tender the birth certificate of the claimant. However, the defendant elicited under cross-examination of CW1, wherein the claimant admitted that he was 52 years old when he was appointed as Director of Works and Maintenance of the defendant. And the Supreme Court, in the case of Adama against KHSA, held that evidence elicited from a party or his witness under cross-examination, which goes to support the case of the party cross-examining, constitute evidence in support of the case or defense of that party. If at the end of the day, the party cross-examining decided not to call any witness, he can rely on the evidence elicited from cross-examination in establishing his case or defense. In such a case, it cannot be said that the party called no evidence in support of his case or defense. But it can, however, be said that the party called no witness in support of his case or defense, but not evidence. as the evidence elicited from his opponent under cross-examination, which is in support of his case or defense, constitute his evidence in that case. In this instant suit, evidence of CW1 elicited by the defendant under cross-examination strengthens and concretizes the case of the defendant. Counsel for the defendant argued that the claimant also agreed during cross-examination that he, the claimant, was above 50 years of age before he accepted the said employment. Chapter 1, Section 1, 020206A of the Public Service Rules 2008 stipulate that before a person can be employed in the service, the person shall not be at least 15 years and not more than 50 years of age. The Public Service Rules 2008 quoted by the defendant is outdated. The extant rule that is operational now is the Public Service Rules 2021, approved by the Federal Executive Council in 2021. The defendant did not tender the Public Service Rules and rely on the decision of the Supreme Court in the case of INEC against Musa. This court held in several cases that the Public Service Rules are not made under any legislation in which the court can take judicial notice as provided under Section 122 of the Evidence Act, since the rules were not tendered in those cases. I stumbled on a recent decision of the Supreme Court, which hold that the Public Service Rules to have been made pursuant to the Nigerian Constitution. The Supreme Court, in the case of Iderima against Rivers State Civil Service Commission, held that, and I quote, in the first place, it cannot be forgotten or overlooked that the appellant was a very senior civil servant in the established pensionable cadre. His statute qualified him to be disciplined or dismissed only in accordance with Rule 04107. In Bashir Alade Shitabe against Federal Public Service Commission, the court said of the status of a senior civil servant on pensionable cadre that the civil service rules of the Federal Public Service govern conditions of service of federal public servants, and they are made pursuant to the power conferred on the respondent by virtue of constitutional provision in the 1963 Constitution. And the rules relevant to these proceedings were made in 1974, pursuant to the provision of Section 160 sub 1 of 1963 Constitution. These rules, therefore, in my view, have constitutional force, and they invest the public servant over whom they prevail a legal statute, a statute which makes its relationship with the respondent and the government, although one of master and servant, certainly beyond the ordinary one, mere master-servant relationship. Under these rules, which I already pointed out, have statutory force and therefore ought to be judicially noticed. Paragraphs 04107 and 04121 provide the procedure for which must be adopted in removal or retirement from service, as well as general discipline of public servants in the established pensionable cadre. Unquote. Given this holding of the Supreme Court, I am bound to take judicial notice of Public Service Rules 2021, pursuant to Section 122 of the Evidence Act 2011, having been made under 1999 Constitution of the Federal Republic of Nigeria. Section 020206 of the Public Service Rules 2021 state that before a person can be employed in the service, the person should not be less than 18 years and not more than 50 years of age. And the evidence before me, the claimant was 52 years old when the defendant employed the claimant in July 2021. This is another irregularity in the employment of the claimant. Now, taking not being a registered engineer, along with being above 50 years of age at the time of appointment of the claimant, are these irregularities justifiable under alien law to warrant the dismissal of the claimant? I have painstakingly read the pleadings and evidence before me. Nothing suggests that the claimant misrepresented his age or academic qualification or membership of a professional body, which now made the defendant to employ the claimant. The claimant could have been found guilty of gross misconduct under the provisions of Section 100402 of the Public Service Rules 2021. In Sepulai Mohammed Aliu against Nigerian Port Authority, unreported suit number NICN/ABJ/20/2023, the judgment, which was delivered on the 3rd day of October, came up before my learned brother, Adeni J. In that case, the claimant was offered an appointment based on his misrepresentation that he has the National Youth Service Corps certificate, and his appointment was terminated for failure to produce the said NYSC certificate as at when due. As found by the court, the claimant admitted that his NYSC certificate was required for his employment, and the said certificate was not produced as at when due during his documentation, and having freely executed an agreement that his appointment will be summarily dismissed if any material fact be suppressed. Accordingly, the court held that the defendant properly exercised its right to terminate the claimant's employment within the probational period. The point to note here is that the NYSC certificate was acknowledged to be a prerequisite condition precedent for employment, the non-production of which vitiated the employment. There was also knowledge on the part of the claimant of the fact that the NYSC, being a prerequisite for employment, enjoining employers everywhere in the country, and before employment, demanding and obtaining a copy of NYSC certificate or an exemption certificate before any employment of a qualified candidate. The defendant failed to refer this court to any law, which the defendant relied on to dismiss the claimant because the claimant was above 50 years old at the time of his employment. Neither was any law supplied by the defendant that empowers the defendant to dismiss the claimant because the claimant was not a registered engineer at the time of his employment. The defendant knew that the claimant was not a registered engineer before the claimant was employed on the 16th day of July 2020. Though Section 020206A of the Public Service Rules 2021 give the age bracket for employment that a person must not be below 18 years and not more than 50 years of age. But there is no any provision for sanction if a person above 50 years or below 18 years is employed. And in the case of Sunday Inyam, Bot, and 4 others against the Nigerian Christian Pilgrims Commission, unreported suit number NICN/ABJ 173/2024, the judgment which was delivered on 19th day of February 2025 by His Lordship, Honorable Justice B.B. Kaib, PhD, where the court held that, and I quote, "It was not pointed out to me, and I saw none in the Act, any provision indicating that the outcome of a recruitment exercise which does not comply with the federal character principle will be null and void. The logic of the rule that where sanctions for non-compliance are not provided by the law or rules in question, then what is being enjoined is directory and not mandatory, as was held by the Supreme Court per ACAS JSC in the case of Bode Thomas against Federal Judicial Service Commission. Must then mean that where a specific sanction is provided, no other can be added. In any case, ambiguity ought to be resolved in favor of an employee." Unquote. The Public Service Rules 2021 does not provide for dismissal of an employee whose age is above 50 years at the time of his appointment. Besides, the defendant did not refer this court to any law, nor am I aware of any, under which the defendant dismissed the claimant on the ground that the claimant did not meet the requirements for employment of the claimant to the Office of Director of Works and Maintenance of the defendant. It is one thing to apply for a job opportunity, which the claimant did, and it's another thing to employ an applicant, regardless of whether the applicant meets the requirement for appointment. The irregularity in the appointment of the claimant is a shared responsibility between the claimant and the defendant, and not a one-sided fault. And in the absence of any law under which the defendant dismissed the claimant due to overage of the claimant at the time of appointment, not being a registered engineer before the appointment of the claimant alone, renders the dismissal of the claimant illegal. But that is not all. More is coming. Lest I forget, the defendant pleaded and led evidence to state that the employment of the claimant into the institution was influenced by the claimant's elder brother, Professor Enetimi Idasoebu, who was then director of the defendant between 2016 and July 2011, in collusion with the chairman of the governing council of the institution, who is also an in-law to the claimant. The court will accord this assertion with a pinch of probative value, as the persons alleged to have used their position to influence the employment of the claimant are not parties to this suit, and their attention was not brought to this allegation so as to allow them to defend themselves. Where a person is alleged to have done a wrong or accused of doing something unworthy and therefore disagreeable, he should be informed to exercise his inalienable right to profile a defense or answer before any adverse taking is taken against him. See the case of Magid against University of Agric Makodi. On the second arm of reason for termination of employment of the claimant, the claimant pleaded and led evidence to state that the claimant was double timing, as he is a pensionable officer in the Bayelsa State Civil Service and also a full-time service in the Federal Polytechnic Yenegoa. The defendant confirmed to the disciplinary committee of the governing council during the process leading to the disengagement of the defendant that he received salaries from both the Bayelsa state government and the defendant from July to November 2021. However, the claimant claimed that the claimant had altered his position by quitting his job at the Bayelsa State Ministry of Transport and is working fully for the defendant based on the offer of employment from the defendant, and tendered a letter acknowledging his voluntary retirement from Bayelsa State Ministry of Transport and admitted same as Exhibit CW014. Though the defendant merely stated that the claimant received salaries from both the Bayelsa State government and the defendant from July to November 2021 without tendering evidence of such payment from both employers, and the claimant also did not deny the assertion of the defendant, neither did the defendant plead when the claimant assumed the employment of the defendant. The law is that where a statement of defense raises new issue of facts, not only arising from statement of claim, the claimant has a duty to file a reply to avoid same being admitted facts by him. See the case of Odera Investment Company Limited against EcoBank Nigeria PLC, reported in 2020, 10 NWLR part 1731 at page 65. Also in the case of Yenegoa against Minister of FCT, reported in 2025, 7 NWLR part 1988 at page 145, the Supreme Court held, and I quote, "It is settled law that a reply is a defense of the plaintiff to the case put forward by a defendant, or even to the counterclaim of the defendant, or to the new facts raised by the defendant in his defense to the plaintiff's statement of claim. There is no general proposition of law that failure to file a reply to rebut an abatement in the statement of defense is tantamount to an admission. However, where a defendant by his pleading set out a case that cannot be met by mere denial and which has not been taken care of by abatements in the statement of claim filed by the claimant, it is a matter of utmost prudence, if not necessity, to file a reply to a statement of defense. And where a plaintiff fails to file a reply to abatement in the statement of defense that has not been taken care of by abatement in the statement of claim, he will be deemed to have admitted the abatement in the statement of defense. While I concede that it is not in every case that a reply is necessary, it should, however, be spelled out that a party who fails to file a reply runs the risk of being deemed to have admitted abatements contained in statement of defense not covered by statement of claim, unquote. The claimant in this suit fails to file a reply to abatement of the defendant, specifically where it was stated that the defendant confirmed to the disciplinary committee of the governing council during disciplinary process leading to the disengagement of the defendant, that the claimant received salaries from both Bayelsa State government and the defendant from July to November 2021. And a careful reading of the statement of fact does not cover this specific abatement. As a matter of law, the claimant will have no option but to deem this fact as admitted. Again, a fact which is admitted by parties need no further proof, since no one set out to prove what has not been denied. See the case of ECHO against Toyo. Notwithstanding the failure of the claimant to provide a reply to the defense of the defendant, a scrutiny of evidence before me reveals that the claimant was offered employment via Exhibit CW001 on 16 July 2021. Exhibit CW014 acknowledged the voluntary retirement of the claimant from the service of the Bayelsa State Government. The voluntary retirement of the claimant from the service of Bayelsa State Government took effect from the 3rd day of November 2021, which means that after the appointment of the claimant by the defendant on the 16th day of July 2021, the claimant was still in the employment of Bayelsa State Government, collecting salaries till November 2021. Again, the defendant elicited under cross-examination of CW1, where CW1 stated, and I quote, "I started working with Bayelsa State Government before I was appointed by the defendant. I started receiving salary with the defendant immediately I was appointed," unquote. It can be therefore gleaned from this piece of evidence that the claimant started receiving a salary from the defendant immediately the claimant was appointed by the defendant in July 2021, while also still collecting salary from Bayelsa State Government before his voluntary retirement, which took effect on the 3rd day of November 2021. From the foregoing, I am convinced and satisfied that the claimant received salaries from Bayelsa State Government and the defendant from July 2021 to November 2021. And the employments are full-time paid employments as against temporary employments. Now, the question that makes my mind unsettled here is whether it is illegal to be in more than one full-time employment. Counsel for the defendant in his final written address, particularly paragraph I, referred the court to section 030402Q of the Public Service Rules, which makes holding more than one full-time paid job a serious misconduct. As I earlier noted, the Public Service Rule 2006 are outdated. Section 100204R of Public Service Rules 2021 makes holding more than one full-time job a serious misconduct. The defendant has proved that the claimant received salary from Bayelsa State Government and the defendant from July 2021 to November 2021. In view of that, I hold that the dismissal of the claimant from the employment of the defendant is lawful and legally justified under section 100402R of the Public Service Rules 2021, and I so hold. It is therefore the finding of this court that the claimant received salaries from two full-time paid employments. It is a gross misconduct under section 100402R of the Public Service Rules 2021, which attract dismissal. This reason alone is sufficient to dismiss the claimant from the service of the defendant. C1 is resolved in favor of the defendant, and I so hold. Given this finding, the claimant failed woefully to prove that his dismissal from the employment of the defendant is illegal to warrant the grant of the relief sought by the claimant. The suit of the claimant, therefore, is dismissed accordingly. On EC2, that is, the defendant counterclaimant pleaded and laid evidence in support of the fact that the claimant had received salary to the sum of $397,611 per month from July 15, 2021 to February 14, 2023. The claimant had received a total sum of 6,361,776 naira from the defendant, though the claimant did not controvert this averment in the pleading of the defendant. However, the defendant counterclaimant has the onus to prove the counterclaim. This is because a counterclaim is a separate action. The effect of failure to file a defense to a counterclaim is the same as that of the defendant in the normal action commenced by writ of summons, who, having been served with a statement of claim, fails to file a statement of defense in challenge of the statement of claim. Even where a statement of defense has been filed and no evidence is laid on it, the defendant is deemed illegal to have abandoned his defense and admitted as true the averments in the statement of claim, and the onus placed on the plaintiff to prove his case becomes minimal. See the case of Olale against Wema Bank Limited. It has been established before this court that the claimant was employed and started drawing salary from the defendant in July 2021 and ceased to be the employee of the defendant via the Exhibit CW007, which took effect on the 14th day of December 2021. between July 2021 and December 2021, when the claimant was in the employment of the defendant, the claimant seemed to be the employee of the Bayelsa State Government on the 3rd day of November 2021. I think it is unjust to ask the claimant to refund the salary received from July 2021 and December 2021. The claimant can only be made to refund the salary he received from the defendant while the claimant was still in the employment of Bayelsa State Government. That is from July 2021 to October 2021. Because the voluntary retirement of the claimant from Bayelsa State Government via the Exhibit CW014 took effect on the 3rd day of November 2020. From July 2021 to October 2021 is 4 months. And if you calculate 397,611 times 4, will give you a total sum of 1,590,445 naira 6 kobo. The defendant counterclaimer is only entitled to the refund of the sum of 1,590,445 naira 6 kobo, being the amount the claimant received from the defendant while still receiving a salary from Bayelsa State Government. EC2 is partly resolved in favor of the defendant counterclaimer. The defendant counterclaimer has successfully proved the counterclaim against the claimant. The claim succeeds, and the claimant is hereby ordered to pay the defendant, the counterclaimant, the sum of 1,590,445 naira 6 kobo, being the total salaries prudently received by the claimant from the defendant from July 2021 to October 2020. And I award this 10% interest on the judgment sum till the claimant liquidates the judgment sum. All the terms of this judgment are to be complied with within 30 days from today, without prejudice to the right of appeal by both parties, and judgment is hereby entered accordingly.
As the court pleases.
As court pleases. Yes, my lord. I thank the Lord for the industry, the details of the extent of the details he went through to deliver this judgment. Be that as it may, even though it went against my clients, I still respect the industry and the details put into it. I'm very grateful, my lord.
Okay, you'll get the judgment possibly tomorrow. You'll get it tomorrow.
As God please. Thank you.
All right.